He is a member of the Association of Experts for Personal Training. He is then providing advice and consultation and liability issues, setting up business, and then the new General Data Protection Regulation. Please, let's give a warm welcome to Dr. Matthias Kroll. Thank you. So thank you very much for these kind words of introduction and for the invitation to come here in the first place. Well, I'll be talking about a topic which is an urgent topic. It's a highly current, in particular, when we look at the Facebook incident. And there, in many ways, we have been witnessing data protection violation. And Mr. Zuckerberg can be very happy that it didn't happen post 25th of May 2018 in Europe, because then the legal data protection situation and framework will massively change. We will have a much more stringent and severe data protection legislation, many more, and tougher fines and sanctions if you do not comply with the new data protection legislation. What is important in the first place is that it is cross-sectoral. It applies to all sectors of the industry, to any size of company. So it's completely irrelevant whether you have a company with 2,000 headcount, 220, or maybe even only 2 employees. You have to observe this new data protection regulation. I think I've got about 30 minutes to introduce this topic. What I will try to do is give you an insight into the new rules and regulation that will apply. I would like to give you some to-dos in terms of what at best you should implement by the 25th of May in your own company. And then last but not least, I also have a checklist we can go through together at the end of the presentation. So let me start by telling you that the Federal Association of Personal Training intends to offer a solution package for members in the coming 2 to 3 weeks. You will get a checklist to ensure that you meet all the requirements, including the corresponding forms you can use to ensure that you do so and that you are in compliance with the new General Data Protection Regulation. So what is it all about? What's the hype? As of the 25th of May 2018, the General Data Protection Regulation in Europe will enter into force. It is applicable across Europe. It will apply without requiring an transposition into German law. There are no interim periods, which means that this new legal regulation will be applicable as of the 25th of May. So by 24th of May, 1 minute prior to midnight, you will have to adjust to this new piece of legislation Europe-wide. As a result, the current applicable the federal data protection laws and many other things, telemedia law comes in here, telecommunications law, all of these regulations, they will be non-applicable as of that date. So why is this of such specific relevance? The problem is the following, that under the new General Data Protection Regulation, each and every violation of the data protection legislation will come under a certain fine when the supervisory body, and this is the State Officer for Data Protection here, the State Office for Data Protection, when this person sends you a questionnaire and you, for example, do not resubmit this questionnaire within a certain period, a deadline, 2 or 3 weeks, then you run the risk of being fined. And this deviates from the new federal data protection law. This is something new. In the old one, there were some regulations that didn't come with a fine. And now the situation is that whenever the regulations are not observed, the corresponding sanctions will be set by the supervisory authority. And this is the major risk you're running. And another risk is that you have to ensure that, well, whenever you do not implement the data protection regulations by 25th of May, you may you may receive a reminder that colleagues out there will surf the internet looking for contact information and information obligations disclosure. Information is met by you. If this is not the case, you will be sent a reminder. In case of a doubt, your fines will be imposed. You can avoid this. It doesn't require plenty of work here. If you properly want to do it, it's quite admittedly involving a bit more work, but I initially said that it applies to all industries, all sizes of companies, and it's really relevant to see when I've got a small company, there is a lot less work and expenses involved than, for example, a VW, the Volkswagen, or the Daimler AG. This is not required by the supervisory authority, but at least you have to address this particular topic, because otherwise the risks coming from outside will threaten you, and trying to escape is not an option. I mentioned it that the General Data Protection Regulation will always apply whenever personal data of EU citizens are processed by companies headquartered in the EU, even if data processing takes place outside the European Union, or when we've got companies with headquarters outside the EU and when they do business and have operations within the EU area. So a few basic terms we have to deal with. Why is it relevant? Because here we talk about the processing of personal data, and privacy is here at the center, of course. And then a few personal words. I believe that in particular in the fitness sector, in the trainer sector, this topic hasn't really been perceived as such. You are sitting here, you are interested people. I think it's super that you are interested, and many of your colleagues haven't even perceived that this topic exists. And I personally think, and I think it's a risky thing to do so. Why? Because in the fitness and trainer sector, when you do a proper job, you, right at the beginning, conduct a regular anamnesis with your client. You look for the ailments, the issues, the objectives of your client and how you can achieve these things. And there you acquire health-related data. It's a must, it's imperative, because otherwise you can't work. So, at the end of the day, you process, in terms of privacy legislation, so-called sensitive data, particular personal data. Even if you're out there on your own as a trainer and work in smaller units, you nonetheless, in terms of data protection legislation, are out there moving in a delicate, sensitive area, because you do process specific personal data. As a result, this data processing of the health-related data is only allowed once you have got a proper approval given to you by your client. It's a highly important point, and in principle, each and every trainer should put on his or her agenda. It's a topic you have to take into account and factor in, and should you not do so, you might run into real problems if you get then reminders of dissatisfied customers, or you have you're scrutinized by supervisory authorities. And well, when supervisory authorities come in, you might say, okay, it's like a tax audit on the part of your Inland Revenue Office. After 10 years, it might hit you like a rock, no doubt about it. It may well be, and many of you may never, ever have anything to do with the data protection authorities. But if somebody may be due to a complaint that was filed or dissatisfied customers, when they are audited, then things will get uncomfortable. And it's an important point. It should be taken as seriously as your obligation to pay tax, even though you do not have to expect audit at any time. So you create an orderly, basic situation in line with data protection regulation and in compliance with your obligations. What does it mean? Within the framework of your data processing methods, you have to comply with certain basic rules. I have a summary here and would like to give you one or two examples. You see, data processing always has to be in line with legislation. It has to be legal, and then it also has to have a purpose. There's a purpose limitation, and then data economy. And let me pick this particular point out. So, indeed, personal data may only be processed if you have a legal basis for doing so, if there is a legitimate foundation for doing so. It is perceived, well, like you can, just like that, save some data. I frequently come across such a situation where people said, I got this from a customer, or from, I've got an ex-employee and still got the data of this person. This is highly problematic indeed, because saving personal data is prohibited as such. To clearly underline it, saving personal data is prohibited unless I have the approval to do so. So this is an important factor. It's a certain understanding you have to develop, and what this approval looks like is something we will shed more light on. So I need legitimacy and I need a purpose. And if there is no longer any purpose for saving the data, and I've got plenty of data records on my computer, it's inadmissible, it's prohibited, and in case of doubt, I have to delete these data records. And this goes along with the basic principle of data economy. I have to keep as little data as possible, as little as I need, and as few data as required. Now, legal bedrock. When may I process personal data? An important point indeed. I've got three basic legal foundations. I say I need data processing. It's required because I have to meet the contract I concluded with my customers. I typically do not need an approval. It's simply about fulfilling contractual obligations, or I move from the bottom to the top, or I've got a legitimate interest in data processing and the other one doesn't have a stronger interest in his or her data not being processed. When you collect health-related data, should you actually have and acquire these health-related data? This doesn't suffice, because whenever you do so, you always require a person's approval, a permission. So please ingrain this in your brain. You may only acquire personal data once your customer has given you a proper approval to do so. And in line with the General Data Protection Regulation, it has to fulfill certain prerequisites. And I wrote down what is necessary in this particular context for you. The person responsible, and that would be you, would be the party responsible. You have to prove that the approval was given in line with the law. It has to be clearly separate from other declarations or statements. If possible, some sort of a frame around it, maybe in bold type. It has to stand out. And what's new here is the right of withdrawal. In this approval and this consent, there has to be an indication that the person is allowed to withdraw this approval. Before, this was not the case. When you then want to get this approval online from the customer, many parties do it because this is expedient, this is time-saving. Then you only may choose a so-called double opt-in solution, which means that you send out the corresponding form to your customer. The customer clicks on the form and tell you that they want to submit a corresponding statement via email. The customer gets a second link, clicks on this link, and then makes the second statement telling you that they approve the processing of their personal data. This is a process and a procedure which is something IT experts can then establish without any problems. So if you want to do it on your own, if you want to tackle this online, you have to do it by choosing the so-called double opt-in solution. Checkbox first, tick in the box, and then click on the emails, the second double opt-in, and then you receive proper declaration of consent and giving you the approval to process personal data. So much for consent, for the approval of the processing of personal data. Just recall, this is important when you as a studio manager and trainer process health-related client data, you need a statement of consent in line with the General Data Protection Regulation. And then second important message I would like to send out to you, I would like to convey, your new customers have to be notified of the so-called affected rights of this General Data Protection Regulation. What does it mean? There are certain obligations in their information that has to be provided: name, contact data, also the question of whether you have a data protection officer. This has to be answered, and then the purpose, the foundation of data processing, and so on. I do not want to go through each and every point because we do not have sufficient time. You can read it in my presentation. It will surely be made available to you on the Glucker-Kolleg website, I'm sure. Then, what is really important is that this information is something you have to disclose, to give to your new customers. You may also provide this information online. You may do so within the framework of the contract conclusion procedure. You will have an online or written contract or some sort of acceptance of your general terms and conditions. And when you conclude this contract, you have to observe the information disclosure and provision regulations. This is at the core of the General Data Protection Regulation. And there are further obligations you have to meet, and you may look at that individually. As I said before, regarding these obligations to provide information, there are sample forms. Of course, you can ask Dr. Google if you want to do so. Just enter General Data Protection Regulation obligations, information provision obligations for enterprises, and there you will find the sample forms. You have to check whether they are fine and then in compliance with the regulation. You can find it on the internet, and we from the Federal Association on Personal Trainers will make available sample forms for members in the 2 or 3 weeks ahead. So, apart from the approval, the consent for then processing personal data, and second, within the framework of the conclusion of the contract with a new customer, you have to provide information on the new obligation in line with the General Data Protection Regulation. And now let me, keep this short. What is important is technical and organizational measures in your company are taken. One of the buzzwords is when you've got a room which harbors your computers, lock it and ensure that there is access control. Potential data leaks have to be disclosed. And the second important topic, and it's down there, this is important. It's a point you should put on your agenda. Do people affected then claim their rights for information? What does it mean? A customer writes to you after your contract was terminated, asking what is the data what is the personal data you saved of me? Send that to me, this information, and please prove that you deleted this data. I had some of my clients, they already received requests from dissatisfied customers based on the General Data Protection Regulation. Currently, we can send back a letter and say the new data regulation was applicable as of the 25th of May and not now. But later you can't. So in your company, in your enterprise, you have to be able to map this, to show it, to illustrated, to be able and ensure that you can provide information, that you may delete the information, that you can prove that you did so. And what is important is there is a 1 month time span for doing so. So this is your deadline. So you have to do quite a bit of work. It's a chunk, and you have to see how deep you would like to dig in this area. So these are the new rights: information deletion, safe from being forgotten, data transferability, right to objection, and then the right to restrict processing. Well, what is order processing? When you cooperate with service providers, basically it's a relatively simple thing. A cloud provider, for example, that hosts your data in the cloud would be a contract data processing entity. So you should really think about which data external service providers you cooperate with. Service providers processing personal data. And you are obliged to conclude contract data processing contracts with them. There are also sample forms for doing so. Dr. Google, again, will be very helpful. And we as a BVT will also give tried and tested forms for order processing, always available to our members only, of course. Here, when you do your payroll in a cloud and have a customer relationship management, which you also store in a cloud, when you send out newsletters via a cloud provider, then the sender of the newsletter is, well, one of these service data processing unities. Some use call service centers, smaller units, and such a call service provider is an external service provider engaging in, service data processing, managing websites, web hosting. This also is included in terms of service data processing. You have to enter into agreement with these people when they don't send you anything. Professional, providers will do so. Then you have to approach your service providers and then tackle the topic. Let me add 2 or 3 sentences on the data protection officer. Often it is said General Data Protection Regulation. What is it about? It's about whether I have to appoint a data protection official, and as an individual entrepreneur, there's no need for me to do so. So it's irrelevant to me. It doesn't play a role. This is not correct. You have to distinguish between two things. On the one hand side, you have to ask yourselves, do I have to appoint a data protection officer? And then we come back to what I've been talking about now, whether you require a so-called data protection management system. And do I have the approvals, the consents, and my website text, are they clearly adjusted to the new legislation, etc.? So they're two different things. Then data protection officer, indeed, when I do not have more than 9 persons, it's a minimum of 10 persons that process personal data. Then in my company, in principle, I do not require a data protection officer. And that leads us to a point to what extent we should view this differently in your sector. I do not want to give a final opinion and assessment of that, because we would have to dig deeper and see. But should you conclude that you engage in a comprehensive processing of health-related data, always depending on what exactly you do. You cannot generalize right here. It may well be that a company with 1, 2, or 3 members of staff requires a data protection officer. This is a feasible occurrence. It's a case-by-case decision. As a rule, when you're out there on your own, when you've got smaller units, less than 10 people working on it, you won't need a data protection officer. But it's a sensitive, a delicate issue indeed, and you should take a closer look. Now we hurry through the individual to-dos, which you indeed should implement and tackle. What is really important is that you write down and list all processes in your company wherever personal data are collected by you and processed by you. Again, there are sample forms for so-called processing registers and lists. And at least in a restricted extent, by listing the processes in your companies, you should draw up such a list. You simply have to sit down one afternoon or over a weekend, think about what you're doing. You write it down, and then you've got your data processing list. Depending on the size of the company, how intensely you're out there, you would have to think about whether you need consulting or not. But please, please do so. I recommend it. Then take a look at your data processing procedures. Think about where health-related data is clearly compiled by you and processed. So again, the web gives you some sample forms. Then you should conduct a risk analysis and a risk assessment, how delicate your processing of health-related data actually is. Again, very important is all legal texts, in particular consents, data protection information, general terms and conditions, and other information or text online, offline, have to be adjusted to the obligation to provide information. Why is it important? Because this is something that has an external impact, in particular your website. Please, the contact information on your website has to be adjusted to and be in line with the general data protection regulation. This is a way of, escaping warning letters. And when there is still the Federal Data Protection Law, the former version, you will get a warning immediately. So please do so. Then also align your general terms and conditions. It's okay. Then this other topic, the order processing agreements, which service providers are you cooperating with? Did they send you some forms, or do you have to take action here? You should do so. And then, last but not least, please be prepared for the requests for the disclosure of information. It may be that a previous client asks you what data have you saved on my person, what has been deleted, have they been deleted or not. You should be aware of the fact that as of then there is a 1-month deadline, and within this period of time you have to respond and you define for yourselves what you have to do. So you have to go through the whole procedure one time. So I've taken half an hour, a bit more than half an hour, to give you a general outline, an overview. It's a very extensive topic, and I put together a checklist here. As I said before, I don't say it's complete, but from my point of view here, we've got the most important points which you at best should implement. Do I have this processing list? Do I need a data protection officer? Do I have all my terms and conditions? Are they aligned with the General Data Protection Regulation? Do I have a process for information provision of, rights of affected parties in connection with new customers? Do I need consents, approvals on the part of my customers? Yes, I do. Do I need order processing agreements concluded with partners? Do I have a process when there are requests for disclosure of information? And then is my website contact information regarding the General Data Protection Regulation in line with the letter? I had more than half an hour. It's a huge, a very extensive topic, I have to admit. My wish, my message I send to you is the following. There is no need to be shocked and, stop moving. No, and on the other hand side, it would be the wrong thing to say, I'm not interested in doing so. I sweep it under the carpet and have the ostrich policy I engage in. You should broach this topic to the extent required, but you shouldn't panic. On the other hand side, you shouldn't ignore it either, because, it's simply too important. You cannot afford doing so, and Facebook should have sensitized that a little bit more. Should you have questions, feel free to approach me. Those who are members in the BPT, they can simply call me just like that and get advice. And apart from that, we will surely find a solution to meet your expectations. I hope that I've been able to sensitize to you to this topic, and I would like to thank you very much for your attention. Thank you.